Good morning, Mr. Calavia.
Good morning, Judge.
Good morning. We're all here. Okay, Mr. Clancy, you have the floor.
Good morning. May it please the court. I'm Joe Clansancy. I represent First Acceptance Insurance Company in this appeal. I'd like to reserve 5 minutes of my time for rebuttal.
Okay.
The trial court's order destroys First Acceptance's contractual right to appraisal by requiring it to litigate the amount of loss before it can compel appraisal. The whole purpose of the appraisal process is to avoid litigation over the loss amount, yet that's what the order forces upon First Acceptance. Litigation.
Can I ask you a question before you get too deep into this? And my question is a jurisdictional question, so that's why I want to kind of ask it early. The Florida Rule of Appellate Procedure 9.130 doesn't appear to authorize an interlocutory appeal from the portion of the trial court's non-final order which denied your motion to dismiss. Do you agree with that?
I acknowledge that the appellate rule we're relying upon permits the right to a review of an order determining the right to appraisal under an insurance contract, and would appear that the motion to dismiss itself is not appealable, but we did appeal the motion to compel appraisal. It was a joint motion. I'm not sure if the court can't, by enforcing the right to appraisal, order the trial court to dismiss the suit, because the policy also contains the legal action against us clause saying there should be no legal action until you comply with the policy. And we would argue that violates the contractual right to appraisal by filing suit. So that would be the argument for the court being able to also dismiss in addition to compelling appraisal.
I don't think there's any support in the case law that says just because one part, is we have jurisdiction in one part, we can get the other part we would not otherwise have jurisdiction for. You agree with that?
I would agree, Judge.
Okay, all right. So I'm not 100% clear. It sounds like you're trying to say, though, we can hear both parts of this appeal, and even in spite of those things which you've agreed with me on. So I'm not clear on how you get us there. You tried to articulate it, but I didn't quite frankly follow it.
The argument would be that by enforcing the contractual right to appraisal, it should be reversed and remanded with instructions to enforce the contractual right to appraisal, and that could be enforced through. We argue in the motion to abate and compel to abate the suit, but we'd also argue that in enforcing the appraisal right, it could be a dismissal of the suit. That would be the argument. I understand there's case law indicating that the motion to dismiss portion of the order is not appealable, though.
Okay, thank you.
Can you
note that
clarify
because
for me the basis of your motion to dismiss in the trial court?
the basis is that appraisal was invoked before the lawsuit was filed, and the policy also contains a legal action against us clause saying that there can be no legal action against the insurance company until there's been compliance with the policy, and that includes the appraisal provision. So the basis was they should not have filed suit. The policy requires them to comply with the appraisal provision before they filed suit, and so we asked the court to dismiss.
And that was the basis of your motion in the trial court? I'm asking because I thought I had read somewhere that argument, but then when I went back, I couldn't find it.
That was the basis in the.
And I'm talking about I couldn't find it in the briefs, but I thought that was the basis of your argument.
Correct. I think it would have been contained in the motion to dismiss the amended complaint, or in the alternative motion to abate to enforce appraisal. Okay.
And I want to follow up on what Judge Morris was asking about. I mean, I think, we don't have jurisdiction to the extent that your arguments is that the trial court should have dismissed the declaratory judgment action because it wasn't a proper declaratory judgment action. I don't think we could get there. jurisdictionally. So, assuming that's correct, where does that leave you?
It leaves us with, again, it was a joint motion to dismiss, or in the alternative, motion to abate to enforce appraisal, which is the motion to compel appraisal. So that leaves us with essentially all the arguments we're making apply to both motions. So I understand if jurisdictionally you can't get there in the motion to dismiss, all these arguments, all the case law we're relying upon, the Progressive versus Hillsborough case, the Glassmedics case, it all applies to a motion to compel to enforce the appraisal process.
Well, one of the difficulties I perceive for your position is that if the trial court had looked at this declaratory judgment action and said, oh, this is nonsense. You're just trying to avoid appraisal and I'm going to dismiss it. It's not a proper declaratory judgment action. The trial court has discretion to do that. And I think you cited the gatekeeping case but here the trial court didn't do that. And there is case law, I think both of you have talked about it, that the trial court has discretion on, when there's a declaratory judgment action that implicates the validity of the appraisal provision, trial court has discretion to go ahead and let that be litigated before allowing appraisal. So A, do you think that I'm accurately reciting what the case law says? And B, where does that leave you if I'm correct?
Correct. So it would be reviewed under an abuse of discretion standard. So we acknowledge that would be the standard for reviewing the order in that regard. There's a Supreme Court case, the San Marcos case, which I think the other side relies upon. But there it was a coverage issue where the insurance company had denied coverage on fraud and misrepresentation. And there the court said the trial court has discretion to determine the order of the coverage issue and appraisal. We don't have a coverage issue. I understand that abuse of discretion would still apply, but there are no coverage issues. First Acceptance Insurance Company, they never.
No, I understand that, but I think one of the cases actually involved the validity of the deck action was challenging the validity of the appraisal provision. And the court said, well, because that directly implicates whether or not the appraisal provision is valid, the court has discretion to go ahead and let that be litigated before getting to appraisal.
Sure, but there'd still have to be a valid argument to actually challenge the appraisal provision. And here, there's not. I mean, the trial court ignored.
That brings us back to, doesn't that require us to look at the deck action, the merits of it, or no?
Yes, as part of the gatekeeping function, should look at the merits of the deck action. But more so, the court should look at the binding case law that resolves a lot of the issues that are raised in the deck action. If an appellate court case resolves an issue addressing the deck action, case law says the issue is moot. So if it's resolved by prior case law, they're not allowed. It's an abuse of discretion to allow them to litigate the issues all over again, where there's multiple cases on ripeness, for example, that resolve the issue. So it's abuse of discretion to allow them to litigate things that have been resolved by the appellate courts. And here, the major issues seem to be one of ripeness. They were arguing that although First Acceptance invoked appraisal, the claim was not ripe for appraisal. They made a couple arguments. One, that there was not a sufficient exchange of information, but under well-settled case law, including this court's precedent of Progressive versus Hillsborough, all the insurance company needed to do is show that they made a payment amount for less than the invoice and invoke appraisal. In that case, the Hillsborough case, the court said once Progressive disagreed with Clear Vision on the amount of loss, it could demand appraisal, and the record clearly demonstrates a disagreement over the value of the claim. What was the record? An invoice and a payment less than the invoice amount. The insurance company is not required to explain, debate, discuss the payment. There's also the NCI case that we relied upon, where they said there's no requirement for an exchange of information. That was one of the deck action issues in their list of issues that there was an insufficient exchange of information. There, the 5th DCA and NCI said suing for more money is sufficient to show that there is a disagreement over the amount.
Well, I hate to keep interrupting you and the flow of your argument, but for me, the difficulty I'm having is more of a procedural, not going to the merits, because I don't have a quarrel with many of your arguments, but I have a procedural conundrum, and that is, how do I get to them, given the posture of this case? Because as I said, at least one of the cases says that the trial court denied the motion to dismiss the deck action. And we have a deck action that's, whether I think it's meritorious or not, it's there, it exists. The trial court didn't dismiss it, and it squarely calls into question the validity of the appraisal. So how do we say, okay, abate, leave that, and go ahead and do appraisal? How procedurally, how do I get, that's a roadblock that I see. So tell me how I get around it. Because I'm sympathetic to, like, this defeats the whole purpose. I get
it. By applying the abuse of discretion standard, I understand that it's, it's a higher standard, an abuse of discretion, but under the case law we relied upon, the trial court clearly abused their discretion. I'd also like to add, this is a little different because they did not stay the breach of contract. So there's a breach of contract count and the deck action count. So there's irreparable harm by also requiring the insurance company to litigate the breach of contract count as well as the deck action count, which is a little different from some other cases. But the essential argument from the other side, and what the ruling does, is it forces the insurance company to litigate the payment amount and prove that it's somehow correct under the policy, that the insurance company, as they say, complied with the policy through its payment amount. There's absolutely zero case law supporting that argument, which is why there's an abuse of discretion by allowing them to litigate these issues raised in the complaint. Demand for appraisal is ripe where the post-loss conditions are met. The insurance company has a reasonable opportunity to investigate and adjust the claim, and there is a disagreement regarding the amount of loss. I've already explained, a disagreement over the amount of the loss is shown by a payment less than the invoice amount. The confusion, or where the court...
I'm only speaking for myself, but I agree. It clearly shows there's a disagreement about the amount of loss. I don't have an issue with that. I'm back to procedurally, I feel stuck.
Where the focus of the order, and I think probably the arguments were this argument that the insurance company did not comply with post-loss conditions of the policy, or did not comply with the policy. That's stated in the order itself. There's no evidence that appraisal is ripe or defendant has otherwise complied with its policy of insurance prior to invoking appraisal. And that ruling, that's an abuse of discretion, because the insurance company, all they had to do to comply with the policy was make a payment less than the invoice amount and invoke appraisal. The order cites cases where, in support of the proposition that First Acceptance had to do more to comply with the policy to make the claim right before invoking appraisal. All of the cases relied upon involve the insured's compliance with the policy, not the insurance companies. We point out in our brief, the only case that we found where an appellate court ruled that the insurance company had insufficient compliance with the policy to invoke appraisal was the Ruddlehammer case. And there it was because the insurance company received an estimate from a PA, and they invoked appraisal without providing their own estimate, without providing a payment. And so there was no basis for the dispute, unlike we have here. So that's the only case where an insurance company that I'm aware of was found not to need more compliance to invoke appraisal to make the claim right for appraisal. Yet the court and AGA, they rely upon all these cases for where the insured had to do more to comply with the policy before invoking appraisal. So that the order itself is just, it's unencumbered by any legal precedent of supporting it. The cases relied upon don't support their position on the ripeness, on post-loss compliance. And if you go through the issues one by one in the declaratory action, I get it that it's an abusive discretion standard, but there's absolutely, there's not a single argument that it has any merit. They even get into the order whether appraisal was invoked before they filed suit, as if first acceptance had to prove that to enforce appraisal, but appraisal can be invoked for the first time in litigation. So that's not an issue.
And
Another
Mr. Clancy, let me remind you, you are into your rebuttal time. Use your time as you wish.
Okay. And so there's an additional argument that the appraiser itself was not impartial, and they wanted to litigate that issue. But as we pointed out, they never even objected to the appraisal. At the hearing, we stated that we can use an alternate appraiser if they have an objection. That's no basis to deny appraisal, which is also in line with this court's own statements in the Hillsborough case, I believe. But I'll reserve the remaining of my time for rebuttal.
Okay, Mr. Clancy, we'll give you 4 minutes for rebuttal, all right?
Thank you.
Mr. Caldevilla.
May it please the court. Good morning, your honors. I'm Dave Caldevilla, and I represent the Appellate Auto Glass America. I respectfully submit the trial court did not abuse its discretion or commit any reversible error, and this court should therefore dismiss the portion of the case where there's no jurisdiction to decide and otherwise affirm. I think Judge Morris and Judge Kelly have hit the nail on the head with respect to the jurisdictional issue, which comprises, I would say, 90% of their brief, continuously argues problems with the declaratory relief claim, that they don't think it has merit, etc. But the trial judge found that it states a cause of action. And so if the insurance company thinks that the deck action is without merit, then they should file a motion for summary judgment or a motion for judgment on the pleadings and get past it if that's what they contend. But you can see from the record that they haven't filed such a motion. They also complain that the judge is allowing us to litigate the breach of contract claim. Well, the reason for that is that they haven't filed a legitimate motion to enforce appraisal yet. But all they have to do is file a motion to stay the breach of contract claim. They haven't done that. They're accusing the trial judge, of making an error on a finding that the trial judge never made. So,
excuse me, file what kind of motion addressed to the breach of contract claim?
They could file a motion to sever, to bifurcate, to stay pending the outcome of the deck action. They filed a motion to dismiss this case, or in the alternative to stay the whole case pending appraisal. But they never said, Judge, if you're going to require us to go first on the deck action claim first, would you please stay the breach of contract claim? They never asked the trial judge to do that. And I'll tell you right now, we will stipulate to that if they file such a motion. But you can't come to the appellate court complaining about something the trial court did or didn't do if you didn't first raise it to the trial court in the first instance. And, right out of the box, Mr. Clancy complains that the trial court is compelling first acceptance to litigate the amount of loss. That is just, and he says it twice during his oral argument. He says it throughout the brief. That is wrong. Number one, the order doesn't do that at all. The deck action claim, which the judge says he wants to decide first, doesn't say we want a determination on the amount of loss. There's a dispute as to which limitation of liability or which measure of damages should apply. That's raised in the deck action. And if first acceptance contends that's not a proper issue for declaratory relief, and they should address that at the trial court. As your Honor said, there's a roadblock on this appeal. Number one, like I said, 90% of their brief complains about the deck action, and without saying that it doesn't state a cause of action, they attack the merits of it and basically contend it should be dismissed. And there's no jurisdiction for that. Everybody's acknowledged that, including Mr. Clancy, but still he wants you to attack the declaratory relief claim, which he can't do. Second, the other part of the roadblock is the case law is crystal clear that when a plaintiff files a deck action that says, hey, they're trying to enforce this appraisal provision against me, and I think it's invalid, or I think it needs to be construed in a particular way that they're not construing it, or I don't think it applies, that type of relief is authorized by Chapter 86 of the Florida statutes, and it's allowed to be litigated first. And the trial judge has discretion to decide that first. And it only makes sense that why are you going to throw somebody into appraisal when the appraisal provision might be unenforceable, or it might be inapplicable, or they might be trying to apply it in a way that's wrong, and then you got to go back to the trial court and have the trial court undo everything. So it makes perfect sense to give the trial court the discretion to do that first. And
Mr. Calavia, with regard to the invocation of appraisal, the letter came from the servicer, not from the insurance company,
so
right?
a couple of problems with that, Judge. There's
yeah,
no proof it even came. There's no proof that it was mailed. And Mr. Clancy seems to think that he can just file a motion without any supporting evidence. He's going to say that hey, your case should be dismissed because you have to comply whenever we send you an appraisal demand, and then he's not going to prove that he sent the appraisal demand. And then the letter itself, when you read it, it says, hey, I'm not an employee of the insurance company. I'm the employee of somebody else, and I'm going to invoke appraisal. Well, if we got that letter.
I understand that, but I'm really not sympathetic. Just again, speaking for me, I'm unsympathetic to that argument because it's clear. The glass company sent an invoice and the insurance company paid less. So it's evident to me that there's a dispute. And then you sue for breach of contract. So I'm not particularly sympathetic to all of that. I don't think that, I think appraisal is designed to, I agree that appraisal with the insurance company's position that it's supposed to be simple. This is supposed to be simple. We don't agree on the amount of loss. So let's go and have an appraisal and have someone else determine it.
And I understand.
Real simple, but for whatever reason, well, I know what reason, but the glass company doesn't want to go to appraisal. So you've successfully blocked it by appending a declaratory judgment action to your breach of contract claim.
We have successfully blocked it. You're absolutely right. And the insurance company, if they don't want deck actions filed against them, they can put in their policy that we're going to have an arbitration provision. And you got to go to arbitration before you litigate this type of an issue. But they didn't do that. And they write, and Judge, I'm sorry, but I understand what you're saying on the amount of loss, but let's get to the issue that Judge Morris raised. And they have a burden to prove that they sent that letter. The law is clear. Just because a letter is in the file doesn't mean that it was actually sent. And they have to prove that they sent that letter. And they can't just walk into court. I mean, it says right on the letter that they sent it by certified mail. Well, why didn't they produce return receipts? Why did they put Miss?
Didn't they not ask for appraisal as part of the lawsuit? Isn't the motion to stay and compel appraisal? So isn't that a request?
They're allowed to do that. Yes, but
so what difference does it make about the letter?
The difference is, Your Honor, is that Mr. Clancy argued that it's a condition precedent to us to even file the lawsuit. He asked you today to dismiss our case because.
So maybe he loses on that argument, but he still asked for appraisal within the litigation.
And we've acknowledged that. He can request appraisal once he's complied with post-loss conditions, which I understand you disagree with me on whether or not we have compliance with post-loss conditions and whether it's within the scope of the appraisal provision itself. The appraisal provision itself says that it's it's only to appraise the amount of loss, and this case doesn't involve a dispute over the amount of loss. It involves a dispute over the limitation of liability. But I understand you, Judge Kelly. I know you disagree with me, so I'm not going to sit here and dicker back and forth with you on
Well,
that.
I'm just one person. I mean, I have the way I see it. I can't speak for my colleagues.
Well, you're a much more important person on that point than I am, but so I'm not going to sit here and debate that with you. My briefs have said my piece on that issue, and I will point to Judge LaRoe's decision in the Kennedy versus Slockett case where he appraised interpreted an arbitration provision consistent with what I'm arguing here. But in any event, I think we're kind of beating a dead horse because there's a roadblock in this case, as Judge Kelly has recognized, and that roadblock is insurmountable. And for that reason, I'm just going to go ahead and rely on my briefs and shut up right now, unless your honors have any other questions for me. I appreciate your time, and I request that you dismiss the portion of this case which asks you to review the dismissal order, the portion of the order that dismisses, and I ask you to otherwise affirm. Thank you, your honors.
Thank you, Mr. Caldavita. Mr. Clancy, what did I say, 4 minutes?
Yes, Your Honor.
Go ahead.
Thank you. If this order stands, there is no contractual right to appraisal in Florida. They can make arguments that completely ignore binding case law. They can contort, essentially mischaracterize or misconstrue case law on what an insurance company has to do to compel appraisal, and raise specious arguments like public policy arguments that have been resolved by the court. It's the ruling itself is just completely not based in any law, in any case law. I haven't even heard an attempt by opposing counsel to make that argument here.
I want to stop you just for a minute because I want to see if you agree with it. One point. Do you acknowledge that there is case law that says if there's a declaratory judgment action that squarely raises the issue of the validity of the appraisal provision, that the trial court has the discretion to go forward with the declaratory judgment action and not order appraisal? Do you agree that case law says that?
Yes, discretion. And it's an abuse of discretion. But also here, where is the challenge to the validity of the appraisal provision? I don't believe there is such a challenge. What they argue is that the insurance company has to do more to show that the claim is ripe for appraisal. That's where the abuse of discretion is ignoring binding case law on ripeness, on what an insurance company has to do to make the claim ripe for appraisal. And they're creating new case law now. There's absolutely no case law in Florida that says that an insurance company has to do more to make the claim ripe for appraisal, that they have to prove that their payment amount complies with the policy, with limited of liability provisions. They're essentially bad faith allegations. It's turning a breach of contract and a declaratory action into a bad faith suit by litigating the insurance company's compliance with the policy. They even make these statements in the count 2 for the declaratory action where they say the defendant routinely attempts to rely upon its appraisal provision to avoid making proper payments. They unlawfully are underpaying the plaintiff to avoid compliance with its policy provisions. It's essentially a bad faith suit. They want to litigate the insurance company's use of the appraisal provision and the policy provisions regarding the payment amount. But how the insurance company arrived at its payment amount is completely irrelevant to the appraisal process. It doesn't matter how they got there, as we explained with the Middleton case and the Enger case. It doesn't matter. I'm sorry?
I just was saying, yeah, the Enger case, right?
Right. So the basis of the dispute doesn't matter. And just because they want to litigate a policy provisions, the limit of loss provision, doesn't mean that they can when the insurance company invoked appraisal. If they can do that, then there is no right to appraisal, because every time the insurance company invokes appraisal, the other side will say, no, we want to litigate how you arrived at your payment amount. That's why it's an abuse of discretion. It guts the appraisal provision by allowing litigation over the amount of the loss. And the appraisal provision, it's the amount of the loss, not the amount of loss under the policy. So how the insurance company arrived at the amounts are irrelevant. The appraisers themselves don't consider the limit of loss provisions. They would only become relevant if after the appraisal process, then the insurance company reduced the payment by a limit of liability provision. And so that's why it's also an abuse of discretion, because it's allowing them to get advisory opinions that will probably never be needed, because the appraisals will determine the amount of the loss. The insurance company will make the payment, and none of the litigation will have served any purpose. It results in useless litigation.
With that, you'll have to wrap it up, please.
Thank you. So we would ask the court to reverse and remand with instructions to enforce the appraisal provision by ordering appraisal.
Thank you, Mr. Clancy. Thank you, Mr. Caldevilla.